What ancient rhetoric shaped modern legal arguments? Imagine standing in a courtroom thousands of years ago, where citizens had to defend themselves without lawyers. They relied on the art of persuasive speaking, which still influences how we build legal cases today. Ancient Greece and Rome developed methods to make arguments convincing, and those methods are still visible in courtrooms now. Think of Aristotle, Cicero, and Quintilian. They created techniques that form the backbone of legal persuasion. These techniques are not just about speaking well but about structuring arguments that sway judges and juries. In ancient Athens and Rome, citizens often had to argue their own cases. They used rhetoric, which is the art of persuasive speaking, to make their points clear and convincing. Rhetoric was a systematic way to craft arguments that could influence decision-makers. Aristotle identified three main types of rhetoric: forensic, deliberative, and epideictic. Forensic rhetoric, which deals with legal cases, is the one that directly applies to courtroom arguments. It's about proving guilt or innocence, right or wrong. Ancient rhetoricians broke down persuasion into parts. Invention was about finding the best evidence and arguments. Arrangement meant organizing those points logically. Style focused on clear, compelling language. Memory helped speakers recall their arguments, and delivery was how they presented their speech. Modern lawyers follow this same pattern when preparing legal briefs or delivering oral arguments. Aristotle also introduced the idea of topics or common lines of argument. These included arguments from probability, cause and effect, and comparison. For example, lawyers today use analogies, precedents, and appeals to fairness or tradition, just like ancient speakers did. These strategies help make arguments more relatable and persuasive. In modern courts, many techniques from ancient rhetoric are still used. Lawyers start with an introduction that states the issue and establishes credibility, which is called ethos. They present facts and legal principles in a clear story, known as logos. They might also appeal to the jury's emotions, called pathos, just like ancient orators did. Addressing the other side's arguments directly is another ancient tactic. Greek orator Demosthenes often confronted opposing views head-on, and today's lawyers do the same by anticipating doubts and weaknesses in their case. This builds trust and confidence. Storytelling and figurative language are also tools from ancient rhetoric. Metaphors and analogies help jurors understand complex legal ideas and remember key points. Over time, these techniques have been adapted to fit modern legal rules and procedures. While evidence rules have become stricter, the core goal remains the same: persuade the judge or jury. In the past, citizens studied rhetoric as part of general education because there were no formal legal professionals. In Rome, advocates used rhetorical skills to representing clients, blending law and persuasion. As legal systems grew more formal, the connection between rhetoric and law stayed strong. Rhetoric became essential for effective advocacy. Some critics worry that rhetoric can sometimes hide the truth or manipulate emotions unfairly. This debate about ethics in persuasion has existed since ancient times. Despite these concerns, the practical value of rhetoric in court has kept it alive. Terms like ethos, logos, and pathos are still used today to analyze and teach how to make convincing legal arguments. So, the techniques from ancient Greece and Rome continue to shape how lawyers craft their cases. They organize facts, connect with jurors, and respond to opponents, all based on methods developed thousands of years ago. Understanding these roots helps us see why certain strategies work so well in court. The art of persuasion, rooted in ancient rhetoric, remains at the core of legal argumentation today.